Welcome to The Workplace, a podcast by CalChamber. I'm Matthew Roberts, Associate General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners. One of my favorite aspects of joining CalChamber from a career as a litigator out there in the courthouses is our focus here at the Chamber on keeping employers just out of the courtroom altogether. As many people know from experience, litigation is fairly unpleasant for everybody involved, sometimes even including the attorneys themselves. However, we all know litigation is sometimes unavoidable because you simply can't deny somebody from filing claims, but you can always put your best foot forward in anticipation of defending against some claims that you might get over time. We have an awesome guest joining us today for a discussion of what are the hottest litigation trends and what steps we can take to avoid or defend against these claims. Let's welcome CalChamber's Senior Employment Law Counsel, Erika Barbara, to the show. Thanks for joining me today, Erika.
Thank you, Matt. Thanks for having me and for the warm welcome. Happy to be here today with you.
So, for some, your voice might actually sound quite familiar, and that is because this, of course, is not your first stint with CalChamber. Even more coincidental, which I find kind of neat. When I joined CalChamber, it was actually to replace you when you left. So, Erika, what have you been doing in your nearly 5-year hiatus from CalChamber?
Yeah, I forgot that we just crossed paths in that way. So I'm glad that our paths crossed again now after 5 years. And I'm also just want to say, just thrilled to be back here at CalChamber. As far as what I've been doing over the last 5 years, I was at a large management side employment firm, and I was representing California employers in all things employment law. So my practice focused primarily on wage and hour class action and PAGA litigation, but I also handled cases that alleged harassment, discrimination, wrongful termination, and other types of employment-related claims. And when I wasn't litigating, I was trying to help clients avoid litigation by providing advice and counsel on all sorts of different issues. Because as you touched on, we do want to do all we can to try to stay out of that courtroom. And prevention is definitely the way to do that.
So you've definitely been in the trenches, and I really couldn't have thought of a better person to share some insights into actually the current state of litigation. So generally, what are the trends that you saw over the last 5 years, especially near the end before you rejoined us?
Yeah, so I did spend a lot of time in the trenches of litigation. I also litigated prior to my first stint at CalChamber, so I've seen a lot of different trends in employment law over the years that I've practiced. But what really struck me the most in the last several years was this steady increase in wage and hour class and PAGA actions. And so when we talk about wage and hour class and PAGA actions, we're talking about cases that are brought by one person, so one current or former employee who's seeking to represent themselves and all other employees who worked for an employer in a certain period of time. So for class actions, that's typically a 4-year period going back. And these are cases that typically involve claims like failure to provide meal and rest periods, failure to pay overtime properly, not reimbursing expenses, and they'll seek damages as well as penalties like waiting time penalties, wage statement penalties, and of course, PAGA penalties. And so what we started to see was that really these types of cases had become a kind of cottage industry for a growing number of plaintiff side law firms. And so there were firms that were literally filing hundreds of class and PAGA actions every year. And many of the firms were filing cookie cutter complaints that alleged the same laundry list of claims in every case, really just changing the name of the plaintiff in each case and sometimes even forgetting to do that. And then in addition to that, we also saw more wage and hour claims kind of being tacked on to single plaintiff cases. So these were cases that were brought by just one employee, as opposed to cases being brought on behalf of a larger group of employees. So whereas in years past, those types of cases would typically allege maybe a more limited number of claims. So for example, a claim for harassment or discrimination, and then some related claims like wrongful termination. Well, then it became more common to see these single plaintiff cases also including several wage and hour claims. And again, there were some firms that seemed to have a standard list of wage and hour claims that would just get tacked on to cases, these single plaintiff cases that they filed.
So you mentioned PAGA, P-A-G-A, of course, and it's this kind of boogeyman out there for us employment lawyers. It's like Beetlejuice. If you say PAGA 3 times, it's going to manifest a claim, and then, we're all sweating bullets and having nightmares. But for those of us who are not that familiar with PAGA, what is it and why are they so attractive to plaintiffs' attorneys?
Yeah, sorry for the shorthand. So we call it PAGA, but PAGA stands for the Private Attorneys General Act. And this is a law that essentially allows an individual who is referred to as an aggrieved employee, allows that individual to step into the shoes of the state and sue an employer on behalf of other aggrieved employees for various labor code violations, and in doing so, recover penalties on behalf of the state. And then any penalties that are recovered in a PAGA case are distributed or paid out 75% to the state and 25% to the group of aggrieved employees. So why are PAGA cases attractive to plaintiffs' attorneys? Well, there's a couple reasons. One, the law provides for the recovery of attorney's fees when a plaintiff or an aggrieved employee prevails at trial or if the case settles. So, for example, if a PAGA case is settled, the first thing to be paid out of the settlement are the fees to the attorneys who filed the case. So if you've got a settlement of, say, $1 million, or really any amount, 30 to 40% of that goes to the plaintiff's attorney for their fees right off the top. And so then what remains gets paid out as penalties with, again, 75% going to the state and 25% going to all of the employees. So there's a incentive or a benefit to the attorneys who file these claims because they can recover a sizable percentage of the settlement for their attorney's fees. Then PAGA's also appealing because the attorneys filing these cases will seek penalties for numerous alleged violations of the labor code and then argue that those penalties should be stacked on top of each other, which will then drive up the value of the case significantly because they're seeking penalties not just for one violation, but maybe for 3 or 4 or 5 or more violations.
Okay, so you're telling us that there's this increase in wage and hour, and I can see visually why, right? This is driven by plaintiffs' attorneys who are looking for a piggy bank or a big score here. But what does this really mean for employers in terms of this increase in trend of getting these letters and these claims filed against them?
Yeah, so what it means is that now more than ever, compliance with wage and hour requirements is critical. So not having compliant policies and practices in the workplace in California can expose you to liability for damages and penalties and can make you a target for a class or a PAGA action, which no California employer wants to be on the receiving end of.
Yeah, and Erika, I think it's one thing just to talk academically, and we do this a lot in our trainings about, what might happen or what the law says is going to happen to you. But I always find real life examples to be way more helpful to employers. It's always the so what, or is this really going to happen to me? And I know, being in the trenches as you were, you would have plenty of examples of how noncompliance can be risky and expensive. What can you share with us about real life examples of what you've seen and what's happened to employers?
Yeah, so a common claim in class and PAGA actions, and one that can be can be easy to allege, is failure to provide accurate itemized wage statements. So as you know, California has very specific requirements for what information must be included in a wage statement. Information like all the hours that are worked, all the rates in effect, meal and rest period premiums paid, and other specified information. And if any of the required information is missing, the wage statement is not compliant, and the labor code imposes penalties of up to $4,000 per employee for failure to provide compliant wage statements. And these are penalties that can add up really quickly, right? If you've got 10 employees or 100 employees or 500 employees. But here's something about wage statement claims. So as crazy as this may sound, cases have been filed because of what can be only minor errors with for instance, the name of the employer on the wage statement. So you could have the employer's name not being the actual correct legal name of the employing entity, and that's a violation. So if the name on the wage statement is different in some way from the employer's actual legal name, or if part of the full legal name is missing, that can be grounds for a violation and for a claim. So if you're in that situation and you have issued wage statements with an incorrect employer name on there, then think about this. Every single wage statement that you're issuing to every employee, every pay period has that inaccuracy in it. And if every one of those employees that you're employing can then recover penalties of up to $4,000, that's going to create very significant risk of liability. So if we're looking at a class action alleging wage statement penalties of up to $4,000 per employee, and you have 100 employees, you're looking at $400,000 in potential penalties. If you have 500 employees, that's $2 million in potential penalties. So the numbers can go up really, really quickly based on what can appear to be really minor violations.
Okay. So, and that is, of course, on top of the attorney's fees you talked about, which makes us so attractive in the first place. So,
right.
Taking a minute for the shock value of some of these seven-figure things to wear off, what can employers do to protect themselves from this kind of claim? How can we put our best foot forward to just be able to defend against this claim if we can't avoid it altogether?
Sure. So as the saying goes, an ounce of prevention is worth a pound of cure. So what you can do right now is audit your wage and hour policies and practices to ensure compliance. So that means reviewing your employee handbook to confirm that you have all the relevant policies and that they're compliant. The law changes, as you know, all the time. So if you have a handbook with policies that haven't been reviewed and updated for a number of years, there could be issues there. For example, all California employers really should have a meal and rest period policy in their handbook. That's the way that you communicate your expectations to the employees about how they should be taking their breaks. You give it to employees at hire, you redistribute it regularly, you train managers and employees on the policy. But compliant policies are only part of the equation. They don't mean anything if they aren't followed. So you'll also want to review the actual practices in the workplace. So is the meal and rest period policy being followed, or are employees being allowed to disregard it and take breaks as they please? While employees may be happy to do so, that creates potential for liability. You also want to determine whether, for instance, the meal and rest period premiums are being paid when breaks aren't provided, and are employees being disciplined when they don't follow the policies. So an audit of your practices can help you identify potential issues like that, but also help you identify additional practices that you may want to implement. So, for example, many California employers have begun using attestations or acknowledgments in their timekeeping systems so that employees confirm either at the end of every day or week or pay period that the time they've entered is correct and that they've been provided the opportunity to take all meal and rest breaks. So those are all examples just tailored toward meal and rest periods. But the advice in general would apply to all of the different wage and hour practices and policies that you would have in your workplace.
So one thing I noticed you didn't mention as far as something that you can use is arbitration agreements. And these have been really a hot topic for the courts for the last few years and the legislature as well. But what we do know from prior cases is that employers still have this tool in the toolbox, and arbitration agreements in general are supposed to reduce the costs and make litigation more efficient. Can arbitration agreements really help mitigate these claims?
I'd say yes and no, or it depends, right? The lawyer answer.
My favorite lawyer answer, by the way, it's always it depends. I tell everybody, if you can say it depends any legal question, you're halfway there.
There you go. So arbitration agreements can be helpful. They can include class action waivers, which means that the employees who are subject to the agreements can't bring class actions on behalf of themselves and other employees, and instead they're just limited to their own individual claims. And there's some benefit to that, and those claims must be heard in arbitration. However, wholesale PAGA waivers are not permissible. So while employees can be compelled through an arbitration agreement to arbitrate their individual PAGA claims, their representative PAGA claims, so those that are brought on behalf of all of the other aggrieved employees, those can still only be brought in court. So yes, it's a tool. And if it's something that you're considering as an employer, it's an issue you want to talk to your legal counsel about, have them help you figure out how best you could use that in your workplace.
Yeah. And we recognize this on the helpline too, which, of course you're spending some time on the helpline for our members as well, but we see wage and hour issues as among the most common questions that we get all the time. So I love your advice, especially about an audit. That 1 ounce of prevention is worth a pound of cure, I think is amazing. Moving off of wage and hour, since you did also do single plaintiff harassment discrimination claims, did you see any emerging trends there too? Like, a type of claim or protected class that saw more claims than we used to?
Yeah, so, we always saw harassment and discrimination cases. But I did notice that there were more being filed on the basis of age in recent years. And that's really not surprising if you consider that the workforce in general is aging, right? More employees are working longer for a variety of reasons. And the older that workers are getting, the more potential there could be for a claim that they're treated differently based on their age.
Yeah, and what's really interesting, you and I kind of shared a story earlier today where I went to a fast food restaurant over the weekend, and, fast food tends to attract younger employees for the most part. You don't want to generalize that. But there was one gentleman who you could tell was just much, much older than the rest of them. And you can just imagine, Erika, the kind of comments that, younger employees might say to a much older gentleman, especially in the fast food industry, how fast paced it is, and the kind of comments that could get you into trouble with age harassment. So what kind of things can employers do, train their managers on to kind of avoid negative conduct towards our aging workforce?
Well, one of the best things they can really do is make sure that they are complying with the California requirement to provide harassment prevention training to all employees. Sometimes employers think, oh, that's only harassment training relating to sexual harassment, but it's not. It's harassment based on any protected class. So educating the entire workforce about what is and is not appropriate conduct in the workplace, which would include comments surrounding somebody's age.
Okay, and let's finish up today, Erika, with our crystal ball, of course, because I know you've got one. Any sense of the litigation trends that we may see actually over the next 5 years, something that we might be able to proactively prevent today?
Yeah, I wish I did have a crystal ball to tell you what was coming down the road. I suspect that we'll continue to see an increase in PAGA cases and class actions alleging wage and hour claims, particularly PAGA because of how easy they are to bring and how fruitful or lucrative the claims can be for the attorneys who are bringing them. But beyond that, it's hard to know. But regardless of what the future holds in terms of litigation trends, we know that compliance is always going to be key. So check those policies, check those practices. Utilize the resources that you have available. And to that end, I'm so happy to be back at CalChamber, and I'm here to help employers navigate the tricky waters of California employment law, whether it's on the helpline or in our seminars and webinars. But again, really focusing on compliance just across the board. That's really your best tool to deal with whatever the future may hold in terms of litigation.
Well, I'm very happy you rejoined us, Erika. Thank you so much for your insight into what employers are fighting these days. And again, a very warm welcome back to CalChamber.
Thanks so much. Pleasure to be here. Looking forward to being your guest again soon.
And thank you, listeners, for joining this discussion on the workplace. Please comment, share, and subscribe to CalChamber's podcast by visiting calchamber.com.